as of now.
Let me call him.
Hello, participants. I can see if you hand raised. Is there any question that is a mistake?
Professor.
Hello, can you hear me?
Yes, sir.
Thank you.
Yes,
sir.
Yeah. नमस्कार सर.
नमस्कार नमस्कार.
नमस्कार. हमारा रजिस्ट्रार साहब भी मेरे पास आए.
नमस्कार.
So shall we start, sir?
Please lift you, please.
Yeah.
Professor.
Friends and all the participants, good afternoon to all of you. We all know that we are inaugurating this 1-week certificate course on intellectual property rights systems in India, particularly the patenting systems in India. And I consider we are all very privileged and very lucky students to get exposure to the emerging field of intellectual property rights, because intellectual property rights are everywhere and they're very important for our socio-economic development. But what we are all lacking is that how to recognize whatever work, whatever R&D outcomes we are generating, whether they qualify for a intellectual property right protection or not. That is a major challenge in our country. And if you look at countries like China, US, Japan, Germany, and all these smaller countries are among the students and faculty of this region, I'm very happy to inform you that we got enormous response, though it is a very highly paid program, 2,208 students and faculty members from almost 7 states: Andhra Pradesh, Haryana, Karnataka, Madhya Pradesh, Maharashtra, and Telangana. The students and faculty have registered for this program, and we have drawn the best faculty from the country, from Government of India, industry, academia, and that is why I'm saying that the students are very, very the latest knowledge, the current trends, and the processes, in protecting the intellectual property what you are creating. You all know that intellectual property is also kind of an asset. The way we all deal with our property like gold, land, buildings, intellectual property also has got the even more powerful tool than the fixed assets or the other kind of assets, what we all now appreciate and we understand. So understanding this intellectual property rights is very, very important, particularly for the new generation, because the economy is knowledge driven and innovation driven. So under this context, it is very, very important. Wherever you go, you will be able to think differently, and it is a process, it is a culture. IP is a kind of a culture we would like to bring among the students and faculty. So that is our effort, not to create such kind of a mental development in the faculty and students to think differently. So that is what is the larger goal of this program, not filing 1 or 2 patents in your career, but it is a cultural shift we would like to bring through organizing such kind of programs. And we are very fortunate to have with us today our driving force at the university, Professor V. Krishnamohan Garu, our registrar, and who is the backbone and is a great supporter for this program. And I welcome Professor Krishnamohan Garu, the registrar. And also we have with us Professor Prabuddha Ganguly ji. He is also our mentor and is a very senior most officer, and a kind of even he has got his own company to promote intellectual property rights. He files, he advises. He was very, very senior top management team member of Hindustan Unilever, and later he started his own company, and he is also adjunct professor of IIT Jodhpur. And we are very, very fortunate to have Professor Ganguly with us. I request him to inspire our students, to spread this message of intellectual property rights in our society at large. Now I request Professor Krishnamohan Garu, our registrar, dynamic registrar, to give his opening remarks. Sir.
Thank you, Professor Purushottamji, and I also welcome Professor Mangaluji and dear participants who have shown interest to attend 6 days long certificate program, knowing the importance of IPR. Needless to mention, role and importance of IPR in any economy in today's highly globalized market context. We need to know the filing procedures and also maintaining IPR so that such awareness through this certificate program is
Suddenly everything is frozen.
Sir, our video got stuck up. I think it's
Somewhere
streaming.
something. I
Yeah.
thought something has happened.
Yes, sir.
Okay.
I think the bandwidth is not sufficient for me.
So you can put up the video, and you can do it without the video. Then, if the bandwidth is a problem.
sorry for the interruption.
Yeah, thank you, sir. It's fine.
I am back to online. So sorry for the interruption. And I'm just explaining how important IPR in any economy, especially when we view it from the perspective of globalized context of the world market. And as it can be seen evidently, all those developed countries where IPR is recognized as an intellectual asset, because of that, they generate revenue decades together on the invention or innovation based on which a new product, new design is introduced. So constantly it generates revenue to the economy. So it is economic development gradually that leads to social development. So both social development and economic development, when they go together, there is an emphasis in the recent past that intellectual property need to be recognized and protected for the benefit of not only individual, the whole society. So any social transformation culturally happens when all individuals work together. Change is inevitable, but change can never happen all of a sudden. Change need to be planned, and how such change need to take place should be given a strategy that is going to work out in transforming culturally. Therefore, starting IPR Center at Andhra University and offering IPR course as a mandatory course ever since the IPR chair professor was sanctioned to Andhra University, it has become very happening university. We started building the ecosystem through these students who are taking IPR course as a mandatory course, eventually recognize the importance of IPR and put their efforts in protecting their intellectual property. Thereby, both the individual as well as society is going to gain. So, as a part of activities undertaken at IPR chair, with a view to bring cultural transformation, cultural change the mindset of individual, offering such program for 6 days long, introducing the procedure for filing IPR and maintaining IPR to the individuals who evinced keen interest. After completion, when they propagate the good of IPR, carrying that certificate definitely is going to provide them a competitive advantage in the job market also. So such awareness on IPR eventually should lead to interest and also action, positive action by every individual, whoever has taken certificate. It is not for certificate sake. It should be for implementation at individual level, and also spread the word of mouth after taking this certificate among the peer groups, so that when the whole society recognizes, especially the education institutions like universities, colleges, recognize the importance of IPR, since the teachers are also known as social engineers, and the responsibility lies on the educators to properly educate, plan, execute IPR related courses, IPR certificate programs, IPR diploma programs, so that the IPR, when it is strengthened, eventually will lead to benefits in the long run And any long run gain is going to happen when people realize the need and necessity of IPR. So in that context, I really congratulate the IPR chair at Andhra University and also the resource persons for week-long orientation come training program, and to provide certificate is going to build not only awareness, but also, I think somebody, yeah, but also bring required cultural change and the change in the mindset of people by referring to such examples given by Professor Purushottamji. In so many countries, so the size of population, why are they so high in terms of intellectual property? Why not India with its size of so big population can't be on the top of the list in the world in the realm of IPR is definitely $1 million question. And if all of us put together our efforts, the teachers, especially people who are into IPR line of activity, and strengthen the educational system and introduce courses mandatorily right from schooling to post-graduation level based on their maturity level. If you can introduce this, there will be definitely an impact and the results is going to be positive. And whatever aims with which the IPR chairs instituted in the country to gain entry into IPR domain, India is going to gain. All of us know demographic dividend is so strong in respect of Indian market, and such demographic dividend is not available elsewhere in developed countries. So the future definitely belongs to the younger generation, Generation Z. And if this Generation Z is educated properly on IPR, it is going to build their personality towards recognizing the importance and the essence of IPR, think divergently, and the creative talent pool that is available in India who are working elsewhere can also come back, and Indian market becomes attractive with the creative products and services invented by this younger generation is going to transform our economy, our society. This is going to solve many of the problems like unemployment and increased economic activity leading to social development, and the constant revenues to both individuals, government, and the expenditure can be very productively can be met from IPR raised resources. So that is what is needed today. So the long-term solution to curb all such economic problems, social problems, definitely it is IPR that is going to mitigate such problems. I take the opportunity wholeheartedly congratulate Purushottam and his team for designing and delivering 6 days long certificate program so that the younger generation, they not only become aware, they also propagate the ideology of bringing IPR culture on the campus, outside, among the peer group. Eventually, the word of mouth is going to spread in the society. So when Indian market becomes strong, definitely on global front, in terms of exports, in terms of revenues generated by Indian IPR, is going to resolve many of the economic problems and make our economy stronger in the years to come. Once again, I congratulate the resource persons, the participants, and the organizers on the occasion. Thank you all. Wish you all the best. Very productive learning leading to social development and economic development. Thank you all.
Thank you very much, Vishnu Mohan Garu, for your very inspiring and very motivating opening remarks. Hope all our participants get enough inspiration from the wisdom of Professor Krishna Mohan's words. Now we have with us Professor Prabhupada Ganguly. He doesn't need any introduction. He's such a tall personality in the area of intellectual property rights. In fact, he is, in my opinion, he is the most senior most intellectual property professional in our country. He has contributed enormously for the development of intellectual property rights in our country. And as I told you, we are all very fortunate to have you, Ganguly sir, with us. And I request you to give your inaugural address so that the students should feel how fortunate they are, for attending this program. And they're all the, the future building blocks for the intellectual property rights in our country. Ganguly sir, floor is yours.
Professor Purushottam, thank you very much. Can I have the sharing rights? Because I want to share some slides. So if I'm given the sharing rights, then I can go straight away to my slides.
You have to share yourself, sir. The arrow mark is
Okay,
there.
I've done it. I've done it. Is the slide come?
Yes, yes.
Wonderful. Wonderful.
Yeah.
So, see, what I wanted to do, that you've heard Professor Purushottam as well as, our Honorable Registrar speaking about three very important aspects. First, they talked about society. They started with society. Then they started about culture. And then they came to knowledge creation and the benefits that one gets from intellectual property rights. So that is the reason I thought, you will hear a lot of details during the course. But I thought of giving you a quick philosophical backdrop as to from where all these come out there. And so I thought the introduction should be titled as knowledge creation, protection, and access for whom? For social benefit. So if the society benefits, you benefit, I benefit, everyone benefits. So that is where we start. So I changed the slide. Someone will have to tell me if the slide has changed. Now I want to first span how society has changed over the last 2 million years out there. And if you look at it, say 2 million years ago, what was society like? When humans and animals and everyone came together with coexistence of nature, it was essentially a hunting society. Then slowly, people learned how to do agriculture. So we became an agrarian society. Then from there came the next step, where people developed, the whole industrial revolution came in. And therefore, we then moved into industrial products and the industrial revolution with the wheel, the steam locomotives, and a whole bunch of technologies that developed during the industrial revolution. So explicit technologies got added. So we were earlier working with natural products as a society. We then added other explicit technologies. Then came in what? Then came in information products. Our computers and software and other things came in. So then we slowly moved into explicit knowledge products and through networks. So networks started developing. After that, what is going on at the moment is what I call as Society 5, which is the Internet of Things. And therefore, we have now moved into a super smart society where we can remotely control. Like I'm giving you a lecture from Mumbai and you people are attending the lecture from different parts of the country. Would this be possible many years ago? Possibly not 20, 30 years ago. Today, we are, because of this very powerful internet, we have all been brought together. So the concept of society changes as we go along in time. What is the next part? What I call as Society 7, and we call it the Metaverse Society. And where we are now beginning to develop technologies where either we have artificial intelligence, products of artificial intelligence, we then also mirror the real world into an artificial world. So you have AR, VR, real world, virtual reality, etc., etc. And therefore, we are slowly moving in the years ahead. What will be the structure of society? Not just humans, humans with systems that are artificial intelligence. We'll have systems with virtual reality. We'll have a whole mix and a hybrid society of natural, artificial, and enhanced, enhanced humans and enhanced things. So now this is the way technology has evolved. And as technology evolves, the whole structure of society changes. We are now into a situation of a very, very fast moving society. So let us come quickly to when does a creation become an innovation? Because we use these words so commonly. So question is, when does a creation become innovation? Only when a creation diffuses into society for use. Therefore, if I develop something, I develop some knowledge, I develop something, but I don't take it to the society, just keep it to myself, then that is not an innovation. That remains only as a creation, and society becomes unaware that I have done something. So, one of the things is that when we develop something, when we create something, the quicker we can go to society, the quicker we can diffuse it to the society for use, will be when we will convert these creations into innovations, and society will begin to benefit. We will begin to benefit. Very important. So when we come to these creations, let us quickly examine how many types of creations are there. So the first part is, I sometimes say I want a better mobile. Okay, I want a better pen. I want a better chair. I want a better car. When we do this and ask that I want something of that type, or I want a plant which will produce more, or a plant that will survive in, let us say, dry climate. It will survive in low rainfall and yet give me all the products that I want from the plant. What do? We are then addressing issues of functionality. And when we address issues of functionality, we use methods of science and technology. And if nobody has done it before, we call them inventions. So, functionality of products and processes and are called, if they have not been done before, they are called inventions. And these could be new materials, new products, new devices, new processes. This could be, new life forms, right? New plant varieties, seeds, curative prophylactic diagnostic methods, etc., etc. So all that, including algorithms, computer-assisted creation, and all those things, all those which address issues of technical improvement are related to functionality. And if this has not been done before, then I have done it, or you have done it, then we call them inventions. We become inventors. Okay? Now, then there is another type of creations. So we don't impact necessarily, or we ignore the functional part. So, for example, if I take my specs, right, the frame of my specs is rectangular. But if I made the frame circular, like what Gandhiji had, circular, if the frame is like that, does the functional aspect change? No. What changes? The shape and ornamentation and the aesthetic aspects. So when you look at those type of aesthetic aspects and play with shapes and ornamentation that don't impact the functionality, these are called designs, right? So we have talked about inventions, we have talked about designs. And then I can write a poetry, I can write, I can sing, I can dance, I create a sculpture, or even the slide which you're seeing in front of you, right? These are words which are not my words, these are known words, but I've arranged them in a certain way. This is a creative expression of my mind. So that's another type of creation. It has nothing to do with functionality, it has nothing to do with shape and ornamentation, but it is a creative expression that I've put. And we can do business methods and whatnot. So there are different types of creative processes that you and I are involved in society. Now, when we do these particular creative processes, what happens? The point that comes about that when I convert my creations into a property, Professor Purushottam talked about it, about intellectual property. What is intellectual? Creation of my mind. I take the creation of my mind, convert it into property. And when I convert it into property, I get some rights. And those rights are given to me by whom? By the government. Okay? It's given to me by the government. It gives me rights. And this is a peculiar right, set of rights. These are negative rights to stop others from using your creation without your consent. So see the power the government is giving you by giving you these intellectual property rights. It is giving you a very, extensive power to stop others from using your creations without your consent. But if they take your consent, they can use, even you can use. So very important is consent, your permission. So this is what you get from intellectual property rights. And very important what you will learn, part of it in the course. But when we talked about, you've heard the word patent. So the moment you hear the word patent, patents protect inventions. Functional features of the creations can be protected by a patent. The shapes and ornamentation can be protected by design registration, right? The creative expressions are protected by copyright. And when you create some words, logos, and others, which link all these products and services to who is making it, so the consumer perceives that, and that's called a trademark, etc., etc. I won't go into details of each one of this, but suffice to say that if you are talking about intellectual property rights, then you have different tools of intellectual property rights, which are patent, copyright, design registrations, trademark, geographical indications, new plant variety rights, etc., etc. So this is where you stand. This is where the law comes in and helps you. And therefore, this certificate course, which you're doing, is concentrating more on patents. But there are other aspects to the whole thing as well. But this is equipping you that when you have your creations, how do you get a protection of those creations? Okay? And how do you then utilize that? You get something in return, and the society gets the benefit of your creation. So we all survive together because of a system like this. And that is why our honorable registrar mentioned that the more you do this, the better it is for the economy. And therefore, he was absolutely correct that we must enhance and increase these efforts in the country. Let's go to the next part. I won't go into details because you will learn this in the course. But very important for us that when we look at intellectual property rights, there are 4 things which become very important. One, that it gives us knowledge ownership. I become the owner of that creation. Because I become the owner of the creation, I get some rights. Where are those rights given? These are territorial. So when I file a patent, when I file a trademark, when I file a design registration in India, I get the rights in India. It's territorial. But if I want the rights in other parts of the world, then I have to file it there and get those rights there. So the rights are territorial, and the time for which I get those rights are also limited. Then there are something called exceptions and obligations, that there are certain, that to see that every law says there are certain things that even if they're protected, the public can use it without prior consent of the knowledge owner. And those come in the exceptions. So suppose I take a patented invention to teach you in a class. Even if I don't take permission of the patent holder, I can use it to teach in a class to my students. Why? Because that falls in the exception, because that is so beneficial to society. And there are obligations that if you are given the right, then you have some obligations back to the society on this. All these details you will learn during this course. So it's very, very powerful. These 4 things should be in your mind constantly. So very important that when I do my creations, I must know how to protect those creations, which tool of intellectual property right will be good for me. And I use a combination of all that to do the protection out there. So therefore, intellectual property rights is such that it does a balancing act of exclusive rights to stop others from making, using, selling. There are obligations that if I have the right, I have to do something for society, and there are exceptions in the law, and therefore it's a balancing act that is done. And you will learn this during the week. The important part is how do you take this to the society for societal benefits? So if in Andhra University, I am doing some creations, I am filing for patents, trademarks, design registrations, copyright, etc., etc. I get the rights. But if I don't transfer it to the society, if I don't give the benefits to the society, if I don't make it accessible to society, then what's the use? Because only when we do that, that I get something in return and the society gets the benefit of my creation. This is the fundamental aspect by which our intellectual property rights become important. And a course like this will give you a feel for how you go about doing this as a useful member of the society. So I've already talked about this. I will not go, but very important part that when you have an intellectual property right, A, you have to make it accessible to public and you have to make it at affordable prices. That is the challenge to you and me as innovators. How do we make something, how do we create something which we make affordable? Because if that becomes too expensive, society cannot use it, then what is the use of doing something like that? So very important for us to be sensitive that when we create something, we make it cost effective, we make it affordable, and that is where the challenge to innovation comes in. And then we make it accessible. When what else can we do? I will come to the next slide, and that is therefore, if I am a possible, IP proprietor, I own an intellectual property, I get the intellectual property rights. What can I do with that? Number one, I can use it. I can manufacture a product. I can use the process which I've created. I can either sell it myself or I can contract it to another party to sell it. Okay. This is how do we do it? Like I can rent my right, and that is called a license. So I can license it to someone for manufacturing. Okay. Now, but somebody else I can market it myself. I can contract it to some other party and earn royalties as per a contract. So that is how I gain and the society gains. And people get employment out of that. Very important for us. Simply getting IPR does not help. You have to do something. You can license your IP to somebody to manufacture, okay, and market, but in certain geographical areas. So you have to create a strategy that if you have your intellectual property rights, how do you, create a strategy so that it is made available to society. You can also sell your intellectual property rights and get some money out of it or get some benefit out of it. That's called an assignment. You will study this in this course. Similarly, you can combine and collaborate. You can create joint ventures. You have some IP, intellectual property rights. I have some intellectual property rights. We put them all in one basket. And together, we have a whole basket of intellectual property rights. Question is, how do we use it together? So we set up joint ventures. We can have in something where you have some intellectual property right, I have some intellectual property right, I allow you to use, you allow me to use your intellectual property rights. And when we do this, we cross-license. So that's another way of doing. You can establish a franchise system like what McDonald's has done. Every McDonald's outlet is a franchise. So what do they do? They say, if you have to use that letter M, right, then you have to come to me first. Number two, in a franchise, if you go to any McDonald's, you'll find everybody putting the similar type of clothes. You'll find the design, interior design very similar. All the bread, etc., they use, they all are made to certain standards. So a franchise system develops. So you can see how the society benefits from like this. Now comes in a very important part. Somebody copies you without taking your permission, start selling. What the law does, allows you to take action on an infringer. So you take action against those who infringe your rights. And you can also donate your IP, etc., etc. So important part here, what I want to end by saying that when today you are looking at all these aspects of intellectual property rights, whatever you do, whatever creation you do, you take a call and say, this aspect of the creation, I will protect this, I will protect in this particular way. I will then go into a process by which I will find partners. I will give them some part of my right, or I will rent my right, or I will sell my right, And that is the way you expand the benefits of what you have done as a creation. And that is where you use the entire process of intellectual property rights and the law. There are two parts, three parts to the story. One part is the law. So the lawyers will look at that. Second part, I'm an inventor or I'm a creator. So question is, when I have created something, how will I get a protection? Who will help me to protect? And what are the best benefits of the protection? Number three, very important, that I have protected it. Now I want to give it. How do I give it? There are various management methods. So you have to manage your intellectual property rights. Very important. So management of intellectual property rights is another very important area. Fourth area, which is important for people like you, it's very, very important that when I have an intellectual property right, I have a property. When I have a property, question comes in, what is the value of that property? So if I have 1 kilo of potato, okay, how much do I sell it for 1 kilo of potato? Now, knowledge cannot be weighed as 1 kilo of knowledge or 5 kilos of knowledge. There's nothing like 1 kilo of knowledge and 5 kilos of knowledge. Okay, I have knowledge. So how do I put a value to that knowledge? That is a very, very, very complex one. And I can tell you, in the whole world, including myself, there are very, very few experts in valuation of intellectual property rights. Therefore, if any one of you as young people, okay, look into this area of valuation of intellectual property rights, it's a challenge. And that, so you put all these things together, and this brings in the issue of management of IPR. And if you can manage the intellectual property rights properly, then it's a great benefit to the nation. It's not only great benefit to you, but great benefit to the nation. And that is how the society will grow. And that is how each one of us will grow and make the world a better place to live in. With these few opening words, Professor Purushottam, thank you very much. And I wish you all the very best for this course. And each and every participant, I'll be looking forward to some outcome of this particular course. And I'm looking forward to these 123 people who are attending. Some of you will become great entrepreneurs. Some of you will become owners of IPR. Some of you will do great work for the society, but all of us together will become useful and responsible citizens. Thank you very much. Namaskar.
Thank you, Professor Ganguly sir, for your outstanding speech. Always you are known for your quality and motivating lectures, because I am one of the beneficiary of my association with you and getting inspiration to carry forward your vision and your thoughts. My dear students and faculty members, it was a wonderful message delivered by Professor Ganguly ji. I think one or two key points, takeaways all of you should note down from his talk. The first point what he said is that how you are able to create IP, creation, protection, and diffuse that knowledge to the society so that the society gets benefit. So that is the key driving force for the subsequent step, protection and bringing to the society by way of diffusion. What is important is you should be able to create at the first place a better production, better products, better services, better processes. So how do you do that? The better. Always, that is what we have been talking to you, is the culture. Observe the society, the way we are doing things, question the status quo, and that is how the betterment comes in the existing knowledge. So that is what all our participants to have, that kind of a mindset in you. Whatever you observe, whatever you are doing today, put that question in your frame of mind and examine yourself whether you are doing, or are there any better ways than what you are currently doing. That is the first and foremost step. And if you are able to imbibe that spirit of inquiry, spirit of questioning in you from today onwards, I think we have achieved our goal, our objective of inspiring you, motivating you, and definitely in the long run, you will be able to come out with such kind of a intellectual property creation. So the first and foremost requirement is that questioning the status quo. That is what you all should start learning how to question the status quo and how to look at the way things are happening currently, and using your knowledge, using your brain. As he said, brain is game of intellectual property creation. Are we able to use our brain? All experts says hardly we use our brain 8 to 9% only. The remaining 92% of brain we never use it. But this, if you want to enhance the utility of your brain power, this course will definitely help all of you, so that your mind will be able to think differently and observe. The foremost important thing is that observation. That is, anyway, for any science, for any scientist, what is most important thing is that the skill is observing. So you observe the society, observe the way things are happening around you, and utilize your knowledge and expertise, the theory what you learned in this course, apply and see how you can improve the current state of affairs, current way things are happening. That is first and foremost, fundamental requirement all of you should learn from the lecture of Professor Ganguly. The second point he said is, of course, is very broad point. It is he has already set a tone for the entire 1 week course. The most important parameter is that management of IP. Now, management of IP, it encompasses from idea to commercialization. Again, each phase of IP life cycle is a subject by itself, and all of you should, whichever field you are working, it is immaterial. As long as you are a creative human being, you should possess this kind of a skill sets. IP management, he said, is a very important word for all of us. So we should learn to understand the various concepts, various processes involved in IP management, which we are going to talk to you this 6 weeks, only with reference to the patents. As he said, there are 8 types of intellectual property rights he has covered. That is also a wonderful introduction about the overall, intellectual property rights scenario in our country. It is also put a wonderful, for all of us, what is that we should learn, what is that we should gather knowledge. But only I urge all the participants, to come out with questions. You should not be only only one side. You should not only listen, but listening is also important. But we have also provided enough time at the end of each lecture so that you will be able to come out with some basic fundamental questions. Make use of this opportunity, and asking question is also, as I told you, is a fundamental requirement to come out, to bring out innovations to the society. So in these classes also, you practice that one first. Asking question is not such a simple thing, lot of physico-chemical changes takes place in your body, mind before asking a question. I used to at least get perspiration when I was a student, when I wanted to ask a question to my teacher. So it's very, very important. Asking question is one of the important requirement in our day-to-day life, and this platform provides you that opportunity. You got the best experts in this field, and I don't think anyone has no questions means I don't accept them as a student. The student should have that kind of a open-mindedness, and you will see a lot of doubt if you are really keen to learn the subject. So many people they don't ask questions, but once a flow starts, then many people will come and join, asking questions. But people should make use of this opportunity in asking questions to these experts. As individuals, you can't reach out to these great experts whom we have lined up for this program. So make use of this opportunity. Each one of you should pose your question in the chat box or raise your hand and ask the questions to the experts. Okay. Once Ganguly Sahab, so he's a very, very internationally busy expert, in his domain. And because he is passionate and because you're all students, so he has taken time to interact with you and to address all of you. So I thank you once again, sir, on behalf of Andhra University, and our Vice Chancellor and our Registrar and our team of DPIIT-IPR Chair at Andhra University. We always get your encouragement and support, which really motivates us, helps us in putting all our actions with your guidance.
Thank you very much, and wish you all the very best. And I wish the entire course great success. Make the best of it. As Professor Purushottam mentioned, he has lined up some of the best people in the country. Please make the best of it. and try and torture each and every resource person as much as you can to draw the best out of them. Please do it. Everybody will be very happy and you will be the best beneficiary. Thank you very much once again.
Thank you. Thank you. Sir, can you take few questions, sir?
Yes, I can.
Yeah. Dear students, if you have got any specific questions, getting Professor Ganguly ji is not easy thing for any one of us. So he has spared his time, allotted some time to us. So please ask few questions to him. As long as you don't know the answer, each question is a worthy of asking. Nothing like that is a great question or a less important question. As long as you don't know the answer to that, it is a very worthy question in my opinion. Yeah, please. How do you, Anandya, how do we manage this question answers?
Yeah, anybody can write in the chat box, sir, or they can unmute themselves and talk also.
Okay. Dear students, make use of it. I've noticed because I've been giving lectures day in and day out. I know somebody should kickstart. Once that kickstart happens, questions pours like anything. So who is that? Who is going to bell the cat first? It is very, very important,
Yes, sir, what type of obligations we can, very good question, excellent question. What type of obligations can we expect? So see, what did I tell you? Very interesting. It's a very, very good question. And mind you, on this topic, right, the whole world is coming together and the whole politics starts with it. What are those obligations? First part, I do a creation. The government gives me the right. What is the right it gave me? To stop others. Let us say an invention, to stop others from making, using, selling, or vending that invention. Now, so what happens? I keep the right and I stop everybody. Right? Now, let us take an example, then you will understand. Suppose I have created a new medicine for cancer, right? And I take a patent for it. What does the right given to me? To stop everybody, including Professor Purushottam, to make this without my permission. Now Professor Purushottam comes to me, right? Says, Professor Ganguly, I want to make it. Please give me permission. So I tell Professor Purushottam, I will charge you $10 million for it. Can Professor Purushottam afford it? No. Then he said, no, I can give you, $1 million. So we negotiate. And then I tell, no, I don't want to give you permission. You go. But Professor Purushottam wanted to do something very good for the society by making it cheaper, by making it things which I can't. So my obligation would be either I make it cheaper and give it to the public, or if anybody else could make it cheaper, then I should give them permission. Now, if I stop Professor Purushottam, then what he can do according to the law. So my obligation is to give it to society and make some profit, but not ugly profit. But therefore, my obligation to the government and to society is to make it and make it available, affordable. But if I don't make it, then I'm failing in my obligation. So then Professor Purushottam can go to the government and tell, Professor Ganguly is being absurd. So the government will intervene. The government has the power to take my right and give it to Professor Purushottam under certain conditions of what is known as compulsory licensing. Very important. So now, so this is one of the obligations. So make it. Similarly, this is one obligation which I told you very clearly. Second obligation, very important, that I have got a right and I have to now make it. Now, when I'm going to get the right, one of the things very important for me is to disclose what I have done, right? In a write-up, and you will learn this in the course. It's called a patent specification. So I have to disclose. If I have not disclosed it properly, then it can be challenged and my right can go away. So one of the obligations is proper disclosure. So like this, there are many obligations that are there. Can somebody read out the question from the chat box or some of the questions that have been raised?
Yeah.
I can answer.
Please read out one by one.
So one by one, if you read, I'll give short answers.
Yeah.
But very good question, huh?
Yeah.
Sure, sir.
So you can read out the question and I'll give you the answer.
Yeah, yes, sir. So another question is that what is the best way to improve theoretical knowledge on IPR?
Okay. So number one is, as Professor Purushottam said, you have to read, you have to study, you have to analyze. You see, this is a subject that cannot be taught. This is a subject only has to be learned. And how do you learn? You have to read, you have to analyze, you have to debate, you have to talk to people and fight on small matters. And only when you debate, you will learn out of that. That is how you develop your theoretical knowledge on IPR. Debate. And for debate, you have to ask questions and you have to speak out. Go ahead. Next question. Next question, please. Yeah. Any other question?
Yeah, sir, am I audible?
Yeah, now you're audible.
So which is the government body for IPR in our government sector?
Very good. Now, in our country, intellectual property rights comes under Ministry of Commerce and Industry. And within the Ministry of Commerce and Industry, there's a department called DPIIT, from where the chair also comes. And we have the Indian Intellectual Property Office. And the Intellectual Property Office then manages and administers intellectual property rights across the country. That is the first part. The second important part is that that there are certain laws in the country, right? And these laws are made by the parliament out there. And therefore, we have a patent law, we have a copyright law, we have a trademark law, we have a geographical indications law, etc., etc. So these laws are the laws which govern it. And each one of this is administered by the Indian Intellectual Property Office. Please, next question, please.
I think that answers the next question. The next question is, under which article government has created this intellectual property rights?
Correct. So I just mentioned that.
Yes. The next one is, who will negotiate the IPR between the pharmaceutical companies?
Okay. Who will negotiate? First thing, they themselves have to negotiate for themselves. Number one. So you have to first, that if you are a company A, I am company B, and somebody else is company C, then ABC will have to negotiate among themselves. Number one. Number two, if you are not able to negotiate, you can get an arbitrator from outside. Say, oh, we are fighting with each other, we are talking. Can you help us to talk to each other? That's called an arbitration process. So an arbitrator can come. Third part, that suppose I and you, I say that Professor Purushottam, you are infringing my patent. What will Professor Purushottam tell me? I am not infringing your patent. Correct? Why should he accept? He will say, I am not. So what will I do? I will take it to the court. Who will then judge it? The judge will look at those, the arguments of Professor Purushottam. The judge will look at my arguments and then give a judgment as to who is infringing or not infringing. So like this, there are different bodies that we can go to. I'm giving you fairly broad answers. For each one of this, you have to go into the nitty-gritty details, but I'm giving you the principle. The broad principle I'm giving you. Please go ahead.
Okay, sir. The next question is, will innovative knowledge help in building super smart society?
Yes. Now, for example, it's very interesting. I mean, last 2 months or 2.5 months, I was in the UK. Okay? Last 2.5 months. Now, interesting part. Most of the houses there, you'll be surprised if I tell you that, when the people go out of the house or they're in the house, with the mobile, they're controlling their fridge. With the mobile, they're controlling their microwaves. With the mobile, they're controlling the electrical power in the house. So when they are not in the house, they say why the heating should be on. So they, there's an IoT. It's the Internet of Things. So there are software which are all there in their mobile. They set the timings. So when the person starts from the office back going home and in near, it also monitors how far are you from the home. So suppose you're 3 kilometers away from the home or 2, okay, the heating system starts so that when you enter the house, the heating goes on. You don't waste electricity, you don't waste energy. And number 2, very important, that when you get all these things done, people who create this, obviously, they would like to protect it using intellectual property rights, maybe patents, maybe trademark, maybe copyright. So that is how the economy comes into the picture. So others want to use it, they will go to these people, take a license, do everything, and take them on. A question that has come, is software patentable? The answer is, it is patentable, but under certain circumstances. So it is patentable, but under certain circumstances. I'm not going to elaborate on that because I think somebody is going to take a session where he'll say what is not patentable, and will elaborate that in software what is not patentable and what is patentable. But in general, is software patentable? Answer, yes, under certain circumstances. Then I think Mr. Venugopal has raised the hand, wants to ask a question. Please ask. Mr. Venugopal,
Yes, sir. No, sir.
you
Thank
want to
you.
ask a question, please? Okay, if not, you can continue with other questions.
So another question is, if I have right and I fail to make it accessible, affordable for benefit of the society, then government can take my rights back.
No, government does not take your right back. What the government does, government says that you have not done this. So you have not met your obligation.
I know
Correct?
this.
It doesn't take it back. Right? But
What?
if somebody wants to use that, government can intervene and give that to somebody, right? And you will get some benefit. You will get benefit. It's not free. You will get some benefit, but you may not get the full benefit that you wanted. So if you go back by about roughly 10, 15, 12 years back, there was a particular case that happened in India. One of the foreign companies had developed a cancer drug and had overpriced it. Then one of the Indian companies went there and said, can you give me a license? Right? I want to, use it. So this company, they negotiated and the negotiation failed. So this Indian company went to the Controller General. You asked who controls it? The Controller General in the Intellectual Property Office, Patent Office. So appealed to the Controller General under law, saying these people have not met their
This is
obligation.
yours.
The company
Then you will talk now.
who invented it
It's
came and
not.
said,
I'm
we
not
have met.
attending for
We have met the obligation. So what was the question? Question was, how did the company say that you met the obligation? Company said, I may not make it in India, but I'm importing it in India and giving to people. See, I've sold so much. So what was the question asked? How many people are suffering from this cancer and how much of drug are you able to give? Can you make it accessible to all or most of them? Answer is no. So the Controller General came into the picture. They said, I will now give a compulsory license to the other party. The Controller General then passed an order, gave the compulsory license to this Indian company, and told the Indian company that when you manufacture this and sell this, you will pay this foreign company so much. The foreign company was not happy about it, so they appealed, but they failed in their appeal. So it is actually going on even now that way. So that is how it happens. So it's a very intricate process, and all of us are very strongly involved in all these things. Any other questions?
Sir, someone is asking what are different career options in the field
Oh,
of
very
IPR.
good question. Excellent. I'm so happy that you have asked this question. Today, your career options are infinite. Why? Now, I will just quickly like to first tell you what has been my career track. My career track is that my whole PhD is from Tata Institute of Fundamental Research in Chemical Physics. Many years ago, almost 50 years ago, okay, when I got my PhD in chemical physics. So I used to do quantum mechanical calculations, very advanced things, etc., etc. So I started as a scientist. Then what did I do? I joined at that point in time, after a few years of postdoc, I joined research, in industry. Then in industry, then began to understand that look, why and how businesses take technology, right? So we were pushing technologies to research, from research to the manufacturing. After a few years, I said no, I took a transfer and I started managing factories to understand how technology is pulled into business. So one is business technology push from research to business. The other is from business a technology pull. So you become an expert in that. Then the next part, very important, intellectual property rights, law. So law is the next career out there. Then what is the next career? Management of intellectual property rights. So you can become a manager of intellectual property rights. Then what is the next part? That you can open up and look at this management part, a very important part, that when these transactions take place, I give you my IPR, you give me your IPR, I sell, you buy. So the financial aspect. So you become a finance manager, a financial career opportunity opens up. Right? Then the other part, that you ask that question about obligation, you can become a social entrepreneur, asking questions. So you can go into the area of sociology and society development. I can go on and on and on like this. So you can see how all these careers open up. Today I am a part of this and a part of that and a part of that and part of something. Today I go out and sometimes represent the country on various things, on social entrepreneurship and others. The other career option, I'm an inventor, I'm a creator, I create intellectual property rights, I use it, I go and make a startup. So what I would say, you can do so many things, but you have to be focused and you have to be committed. But opportunities are enormous. It's a very good question. This is the intention of the course also. So you have gone to the very heart of the course. Why this course?
Yeah.
Right? So
I would also like to supplement. I would also like to supplement, sir.
Please.
You see, if you are an electrical engineer, you may get a job in only in electrical field. If you are a lawyer, you may firm. If you are a pharmacist, you may get only in pharma company. But IPR is such a field, it can absorb each and every intellectual. Only requirement is you should have that kind of a mindset and ability to think differently, ability to analyze things. So IPR is such a big platform, it can absorb and provide opportunities to all the human beings who have got that kind of a mindset, intellectual mindset.
Any other questions?
Such a wide field.
Any other questions?
Question, please.
Yes, sir. Another question is, I'm working on a drug and invented new formulation. At the same time, another person has done the same thing, for whom the patent rights will be given.
Well, I will not go into great details of this because these are part of the course. But because it's a question, I'll give it a one-line answer. And that one-line answer, the patent right is given to the person who files the patent first. And that is called a priority date. So if I and you are working on the same thing, but I go and file the patent first, even though you started the work first, I go and file the patent first, I get the right and you don't. So therefore, very important, in this race, it's very important to know not to just only run the race, but from where to start running the race and when to start running the race. Very important. But these are part of the course. I'm sure in the coming 6 days, you will learn part of this. And this is called a priority. Who has the priority is the word. And somebody will tell you about this. Especially the person coming from the patent office who will tell you about filing. Why? that you have got some idea. You create a proof of concept. You prove that, well, my idea works. It may not be perfect, but then should you wait till it becomes perfect to go and file? Answer is not necessarily. So you will file a patent, when you have the proof of concept ready and you have some examples to cite your proof of concept, then perfect it. And then the people who will do the course will tell you how it will take you to the next step and next step and next step. But very important, when do you start? If you start late and somebody else started before, they win the race.
So an extension to that one, he is asking again, are there any prior procedures, like while you are in the middle of the work, can you put a proposal that you are doing research on that particular drug?
No, then you make a public disclosure. Then once you make a public disclosure, then you can't go and protect. So you have to first protect, then make public disclosure. Therefore, it's very important. First you file a patent, then you publish. You don't publish first and then go to file a patent, because then you yourself have made it open to public and then you can't patent. So you have to file a patent first and then you can publish. So tomorrow, if you have something and you want to go to a conference, if you have made a presentation in the conference, then it will be very difficult for you to file a patent on that. So you first file the patent and then go to the conference.
So the last question is, how long a patent right lasts?
Good. A patent right lasts for 20 years from the date on which you file the patent, but provided the patent office has examined and your patent, your patent application has got the patent, then it is 20 years from the date of filing. But you have to renew and pay a renewal fee every year for those 20 years. So it is valid for 20 years. But if you don't pay the renewal fee, then it goes into the public domain and anybody can use your patent because you have not paid the continuation fees. So that's very broadly. I hope I've been able to answer everybody's questions, but I'm very thankful to you and to Professor Purushottam for giving me this opportunity of meeting all of you, even though virtually. But these days, virtual meeting is as powerful as a physical meeting. So thank you very much and wish you all the very best, and God bless.
Thank you. Thank you so much, sir, for your answering our students' doubts very eloquently and very clearly. Really, I should also compliment the students who have asked really very wonderful questions. That gives a lot of satisfaction to the resource person as well, and that shows how keen they are to learn this subject. And that is, in fact, asking questions is the ultimate respect, to the faculty member. If the students, they don't ask any questions, I would say it is not a adequate respect we are given to our faculty member. So the respect and the questions, I feel, they're all proportionately related. So we have got wonderful questions, and I compliment all the students. And also, I thank you very much for sharing your experiences. It's not a bookish knowledge. Basically, all these things comes by virtue of your experience. They can't find solutions or answers to such kind of a questions. So we are very, very thankful to you, sir. Look forward for your continued guidance and support and inspiration to all of us. And thank you very much, sir.
Thank you very much. But my point is, what use is it if in my last so many years, whatever I've gathered, if I can't share, then what's the use? Yeah. So I'm happy to share, and wherever if I'm useful, I would certainly try to share as much as possible. Thank you very much once again, and wish you all the very best, all of you, for this wonderful course. Thank you.
Dear students, Professor Ganguly will be, if anyone who is looking for a career opportunity, he would be a wonderful mentor for all of you. And he will be also there in all committees of the government. Wherever you go for seeking a job in the area of IP, he will be there. So maintain a good knowledge exchange with him and keep in touch with him. He is always available. Because it's my own personal experience. Anytime I call him, he always responds. Send a message, interact with him, and seek all the clarifications to your doubts. maintain a good rapport and network. Your net worth is nothing but your network. The networks, maintaining networks is very, very important in the current era of knowledge economy. So maintain a good rapport with all the resource persons. That is what I urge all the students. We provide all their contact numbers, and they can also interact during the question answers. That is the first step. The faculty member, the resource person will remember you, and he will be able to find time to give replies to you and guide you. So make use of this opportunity and interact with all the faculty members. And if you find any problem, of course, we are here in Andhra University. We are also equally accountable, responsible for all your doubts. So if you are not able to do it, you can also reach out to other members using this network. So thank you, sir. Thank you very much.
Thank you. Namaskar. Okay.
Yeah. Okay, Ananya, what next?
So we will give some break. The
Okay.
next session was about to start from 4 o'clock. So we will start it from 4 o'clock.
4
So
o'clock.
participants can have some break for 7 minutes now.
Yeah. Okay, participants, come back quickly. Very, very interesting. You should not miss any class unless there is an emergency. That's what I urge all of you.
Sure.
Yeah.
సార్ రిలేట్ అంటే
Hmm.
ఈ అకౌంట్ ఇవాళ ప్రొవైడ్ చేయమంటున్నాడు సార్.
ఇవాళ చేయాలంటే
ఇవాళ చేయాలి, కొత్త అకౌంట్ చేసి చేసుకోవాలి. ఏంటంటే ఫండ్స్ సపోజ్ వేరే దానికి రిలీజ్ చేసిన ఫీల్డ్ వర్క్ రిలీజ్ చేసిన దాన్ని సెపరేట్ చూపించుకుందాం సార్.
అదే ఆ మీటింగ్లో అడిగారు, ఉన్న అకౌంట్లో ఇస్తే మాకు యూనివర్సిటీ పర్మిషన్ తీసుకోవాలి.
Good afternoon, everyone. So, are you guys ready, or you need some time?
Yeah, ma'am, as of now, 93 are there. Earlier, before the session, we are 130, more 20 members, I think.
Maybe I will start the session because time is running out. So, am I audible, right? I'm clearly audible?
Yes, ma'am. Yes, ma'am.
Okay, thank you. So, this session about, by the way, Bobby, I can see your hand raised since the session started. So, is it by mistake, or do you really have some question? Bobby Woody D, do you really have some question? You can ask it right now. Okay, I don't think there is. So I'm requesting the admin to kindly lower the hand. I'm requesting the admin to kindly lower the hand. Thank you. So I will share my presentation. Yes, please. Ram Nishant. Yes, please. You can unmute yourself and talk. Are you going to type? You can talk. So you want all the PPTs? That's a good idea. So you have to lower the hand, right? You got it, right? Okay. So we will do that because the exam will be based on all the sessions. So we will share the PPTs in that WhatsApp group. Yeah, sure. I can understand. We will share that in the WhatsApp group. Is that okay? We will not be certified. Yeah, sure. We will share in the WhatsApp group. So, yeah. So can I start now?
Yes, yes.
Thank you.
Okay, ma'am.
Let me know the slide is visible.
Yeah.
Yeah. So in the first session, you came to know about the intellectual property rights and all kinds of IPR and the basics of IPR, right? So this session is about patents, mostly about patents. Patent is the most important, I shouldn't say most important, maybe the most famous one. Everybody knows about patenting. So it's very relevant to the academic institutions. I guess most of the people out here, the participants, mostly you are from academic institutions. So patent will be very important for you guys. So maybe you pay some attention, right? So this is about basics of patents and then non-patentable subject matters in India. So once you go through the slides, you'll understand that there is some basic criteria for patentability. Along with that, there are some subject matters in India that is not patentable. So if you satisfy the patentability criteria also, still you are not you will not get the grant on those kind of subject matter. So that is the topic of this section. Okay. So in this class, covered is first of all basics of patent, then patentability criteria in India, then non-patentable subject matters in India, as I already mentioned. What is a patent? So a patent is an exclusive right. So please remember, a patent is an exclusive right granted for an invention. So, somebody, I have heard some people saying that this guy always talks about this, so that dialogue is patented. That is not the right term. The patent is not given for any dialogue or things like that. Patent is only available for invention. Okay. So here, let me find something. So patent is only granted for an invention. This is very important. So it can be a product or a process that provides, in general, if it is a process, a new way of doing something, or if it is a product, offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. That means when you are writing the patent application, you are disclosing all the technical information, right, about how you are carrying out the invention and things like that, and that the patent office will make public. So the technical information about the invention will be disclosed to the public. And this definition is given by WIPO. WIPO is World Intellectual Property Organization. That is the mother body of IP in the world. Any question? I'm going to the next slide. Hope not. So, okay. I have given the full form of, yeah.
Yeah. So the new way of invention, will it comes under the reinnovation, reinventing the same thing with the new process improvement will comes under this, right?
Yeah, that will also. So you will see that if you improve some process in such a way that it's really a significant improvement, then it can be patented also. So there are some criteria. I will come to that. Just
okay.
Hang on, okay. So this is one important line to remember. The patents are given for inventing new product or process that is useful in day-to-day life. So patent will only be available for things that is useful for the society, that you can use in your day-to-day life. For example, some formula, some mathematical formula like E is equal to mc square, we don't use it in everyday life. For example, I'm sitting here, but I don't need E is equal to mc square, right? So that kind of thing will not get patent. That is called discovery. Those are the path-breaking discoveries. With that, the science progresses in the society. That is not eligible for patent. Patent will be for invention, not for discovery. So this line is very important. I might get some question also in the exam that patent is for discovery or patent is for invention. So see, one question is leaked already. Patent is for invention, not for discovery. Okay. And patent is quid pro quo. Quid pro quo means you give something and get something in return. So you give the technical disclosure. See, here it is written, technical information about the invention must be disclosed. So you disclose it, and the patent office will give you the grant based on the examination and things like that. So it is called quid pro quo. You give and you get something. Okay, that's a Latin word. Why patent? So why we need to have this patent system in the world? First of all, the patent system fosters technological innovation by providing an incentive for R&D. So when you have got the patent and you have commercialized the patent, you get some money out of it. So that is actually you are paying back in the R&D that you have already spent. Then it disseminates the technical information also. In the patent application, we will disclose everything, so that disseminates the technical information among the public, and then it promotes technology transfer also. These are some of the benefit of patent system in the world. So I guess most of the participants here in this course are PG students. So if you are from MTech or maybe MSc, I'm not sure, but in your final year project, you will do some project, right? So if you consider that as a research, then there are some outcome of your research. In general, what happens if you have done some research, and these are for all the PhD students also. I think among all of us, all of you, some 18% were PhD students. So this is very important for you, this slide, that in general for research, what happens? You write a paper, then you send it to a journal, right, for paper publication. Then they send it to a few reviewers. So you send it to a journal, the journal send it to a few reviewers. They will check whether there is any it is good or it is bad or it needs some modification or something. They will send it back, you will modify accordingly, and then your paper will be published. So the reviewer decide whether it is readily acceptable or acceptable with minor revision or acceptable with major revision or not at all acceptable, they can reject also. So this is the regular way of regular outcome of your research. So in this outcome, you publish a paper. So you can add that publication in your resume, and that adds some fame and glory in your CV. But there is an alternative route. In general, in India, even when I was doing PhD, I had that idea, whatever I'm doing, immediately I have to publish it, right? So the moment I publish it, actually I cannot go for patent. So here, that's why I'm mentioning it, that this is the regular route where you publish paper, but there is another route. That is, here I'm calling it the alternative route. So here you filed a patent application before sending it to journal for publication. Here I told you, you can send it to a journal. So before doing that, you file a patent application. Then the patent office will examine your application. If your application passes through the examination, you will get a patent grant. That means you get the patent, you have the patent. Now you have some legal right. If the patent is commercialized, you get money also out of that. But if you have a paper, you don't get money out of that, right? Nobody gives you money for having a paper, but that adds up in our resume. That's a different thing. But patent is a legal right. Okay, and you have some right also. I will go through that. I will explain that in the next slides. But when your patent is commercialized, you will get money also. So in this outcome, you get a patent. That outcome, you get a paper. This also adds some fame and glory in your CV. What is the nature of patent right? So here I told you that you get a legal right. Here, if you are not sleeping and looking at the screen, you can see that I am showing some laser light. You get a legal right. So what is the nature of those right? First of all, this is exclusive right. The patent owner who has got the patent has the exclusive right to prevent or stop every third person from commercially exploiting the patented invention. Okay. And then how long can I enjoy my patent right? Somebody was asking in the last session. 20 years from date of filing or priority. This is important. 20 years is counted from what time? So that is counted from the date of filing, or priority means your first filing. So this is also one important question may come from here. So you got two questions already for your exam. One is patent is for discovery or for invention. So you take invention, don't take discovery, right? This is one question. The next one is how long the patent will be in force. What is the term of patent? What is the duration of a patent? All these things can be the question. So the answer is 20 years from date of filing. Remember, date of filing or priority, not from anything else. Then where is the right available? This is another important thing. A patent is a territorial right. So if you apply the patent application in Indian Patent Office, you get the grant. So you have the right only in India. Anybody can make use or do whatever he wants with that invention in Pakistan. You don't have the right to stop that guy because you didn't file it in Pakistan. Forget about Pakistan. Anybody can do it in the US because you didn't file it in the US. So whichever country you file the patent application and if you get the grant, in that country only you can have the patent enforced. So patent is called a territorial right. A patent granted in India is only valid in India. Then one question I have added here because I have seen so many people asking me the question, how do I get a global patent for my invention? You don't. There is no way that you can get a global patent. The patent will be for only that country where you have applied and you have got the grant. So this is another important thing. Territorial right granted in India is valid in India only. Any question?
Ma'am, good evening, ma'am.
Good evening.
As you said, you don't have a global patent for any of my invention. Suppose the company is running over more than number of countries, suppose for 100 plus countries.
Yes.
They have a global right to, and they don't have a
global right.
they don't
So you have
right.
to file in those countries. Once you get the grant in those countries, you have right in those countries. Not one application can give you global right. Did you get my point? For example, if you want to, if I am the patent owner and I know whatever I have invented, my patent is that has got a good market in India, in US, in UK, in China, in Japan. So what do? I file in all these countries. And if I am an MNC, a multinational corporation, and I am like maybe I'm IBM, so I have offices all over the world. So you file all over the world. I mean, you choose different countries, mostly all over the world. So all the offices you have to choose. But once you get the grant in one country, you have in that country only. So you pay, you file in all these countries, you get the grant. Now you have your right in those places.
Thank you.
Is that clear?
Thank you, ma'am.
You're welcome. So,
Ma'am,
yeah.
Ravindra Prasad here. So wherever the patent owner applies for the individual patent right from that particular country, it is still valid for the duration is same for all the territorials. Like the 20 years is for India, maybe a vary from other US country like 15 years like that.
No. It's 20 years. Always 20
20
years
years
from
for
date of
all
filing.
over.
Yes, from date of filing.
Okay, fine.
Good evening, ma'am. This is
Yes.
Tana. And of late, I've seen that yoga has been patented for USA.
Okay.
Right, and we all practice it over the world. Then
Yes,
can you
recently.
just throw some light on it, ma'am?
Yeah, file opposition.
I
It
guess
should
the
not be
origin
patented.
is India.
Yes, absolutely. File origin, file opposition. I'm with you. So
Thank you, ma'am.
that is what happens. You know, there is. So if I talk about all this story, my session will be gone. So there was something that haldi means turmeric. That you can apply it on your skin for some antiseptic properties. We know that in India
Yes, ma'am.
since our childhood, right? But somebody in the
Yes, ma'am.
US, they filed for a patent and they got it.
Yes, ma'am.
So that's long ago. Actually, they got it. So what happened?
Yes, ma'am.
Indian government, they fought for it. That is our traditional knowledge. So we call it traditional knowledge. So, but people, the patent examiners sitting in the US, they are not sure about it, right? They don't know that Indian people, they know about turmeric. They don't know. So they granted. It's not their fault. So what happened that our Indian government, along with CSIR, with the help of CSIR, they created traditional knowledge digital library, TKDL we call it. So there CSIR, they have collected all the information. I have that slide also here. So that is now available to all the patent examiners. So they can now stop from all these things getting patented. Now the yoga thing is not good. So let's see, somebody will file opposition. If you are ready to file opposition.
No, thank you, ma'am. Yeah, I'm doing my law, and I understand that. But where is the transfer, ma'am? There is no transfer of technical know-how into US because I guess we Indians are well equipped with the asanas and all other things. But compared to US, how was that? What is the basis for they being granted a patent there?
No, whatever you are saying, that dissemination of knowledge in the patent application, you have to see open the patent application. It will be available online. So if
Okay,
you
ma'am.
see what they have written, the patent examiner is satisfied. So see, I'm not aware about this yoga patent being granted. So I
Okay.
need to search it and see it. But you can see the patent application, and whatever they have described in the patent application, that is their disclosure to public. Okay.
Okay,
But
ma'am. Thank you, ma'am.
regular asana, it should not be patented.
Yeah, ma'am. Thank you.
Yeah, you're welcome. Okay, going to the next one, or any more question? Going to the
Go
next
ahead,
one.
ma'am.
Okay. Okay. So here I have exercise for you guys. In the last slide, or maybe last slide only, I talked to you, I described about the patent term. So people who were still listening, you can answer this question. So you have filed one patent application on 1st September 2020. Your application was published on 1st May 2022, and the patent was granted on 29th September 2022. So when will your patent term expire? So these are the answers. So you tell me.
1st September 2040, because from the date of filing.
Yeah, right. So excellent. You guys are not sleeping. I'm happy. So this is
Thank you,
another
ma'am.
question. Is that another question is in the exam? So you already have got 3 questions for the exam. This is very important. If you are attending patent class, you will be able to understand. Otherwise, in general, people think that the grant is from date of publication. Sorry, the term is from date of publication or date of grant or something like that. But it's not like that. It's from the date of filing. So only 3 of you, I think, answered. Other 120 people, if you are still listening, so that is from the date of filing. Okay. Now, section 48, if you are not a law student, this is 48 might sounds very odd here. So that is section 48 in the Patent Act, Indian Patent Act. That section 48 talks about rights of patentees. So when you get the patent, what are actually your rights? So first of all, where the subject matter of the patent is a product, I told you it can be either a product or a process. So when it is a product, the exclusive right is to prevent third parties. So you see, the next one also for B also, when is the subject matter of the patent is a process, and for A it is product. The exclusive right is to prevent third parties. Here also the exclusive right is to prevent third parties. Those are the same. So for product, it is from the act of making, using, offering for sale, selling or importing for those purposes that product in India. So basically, see, these are legal language. If you are not from law, you will think like, who the hell talks like this? In legal terminologies, you talk like this. So this is basically, if I have got one patented product and you are my best friend, but still you are not supposed to make that product or use that product or offer or sell that product or import that product without my authorization. So I am the patent owner. I have, all these rights, so I can prevent all the third parties. So that is for product. And if it is a process, you can see here from the act of, so what they can prevent from the act of using that process, and from the act of using, offering for sales, selling or importing for those purposes, the product obtained directly by that process in India. If that sounds very complicated, just remember that for a product, any third party cannot make, use, offer for sale or import that product. If it is a process, any third party cannot use the process or the same thing that is there for the product, for a product that has been obtained by that process. So So these are the two rights that the patentee will have. But remember that the patentee does not have the direct right to make that product, to use that product, to sell that product. He doesn't have any of those kind of right. That's why the patent is called a negative right. The patentee gets only the right to stop every third person, stop everybody. That is a negative right. The patentee doesn't get the right to use that, to make that, to do, or something. The patentee doesn't get that. Patentee only gets the right to stop everyone else who doesn't have the patentee's consent. This is just for your GK. The first patent in India was on 3rd March 1856. So that at that time, so you can understand the patent system in India is very old. At that time, we had British era here, British Raj here. 1856, a civil engineer named George Alfred Deepening from Calcutta, he filed a patent. He filed an application for a pankha pulling machine. You can see in this picture also. We have seen it in old movies like that. Somebody will sit and draw the pankha, from outside the home, outside the room. So this guy made some machine for that. So no manual intervention is needed. You can drag it. So that was the first patent in India. Our current patent act that we study and we talk about is the Patents Act 1970. It came into force in the year 1972. So maybe I will do that. So Patent Act 1970. This also you need to remember. Maybe this will be your question number 4. This I have already told you, patent is for invention, not for discovery. The patentee gets the legal right to stop everyone from making, using, selling. Okay, I have already told you this. What if patents are given? So this is important. What if patents are given for discoveries like mathematical formulas or equation like E is equal to mc square? Why the patents are not being given for these things? Basically, what you get when you have a patent, you can stop everybody from using that, right? If you get one, if you discover some formula that is very useful in physics or mathematics or any basic science in general, and then if you have that patent, so basically what you are doing, you are stopping every other person from using that. That is not the motto. So if you get patents on things like this, then you are stopping science on art, then we are stopping the progress of mankind. So that is not that we don't want, right? That's why patents are only given for invented device or process or composition that is useful in the society, making sure that no basic science discoveries are stopped. No basic science or discoveries are not stopped. Okay, I'm sorry for writing like this. No basic science discoveries are stopped by patenting. Okay, so basic science, when there is a path-breaking research result, when there is a groundbreaking research result, those things you are not, nobody will give patent for that, because you cannot stop the progress of the mankind, you cannot stop the science in general in the world, but you will get a patent for safety pin. Okay, anything that is useful in your day-to-day life, that is patentable. You don't need to invent a big thing. It can be very simple. For example, I'm not sure, but this thing, if you have this, so you can hang it from something. So things like that also, I'm not sure, you have to search it whether this guy has got patent or not. But this kind of thing, which is very useful kind of thing, so that you can get a patent for, but you cannot get a patent for like all these formulas that will be useful for science, for progress of the science. Those things are not patentable. Patent is only for useful things in day-to-day life. So this is another important line. Not for groundbreaking discoveries like Earth has gravity. For example, if somebody had given a patent to Newton for inventing this, Earth has gravity, then what happens? Nobody can stop. Like, what is the point of getting that? Because nobody can stop anybody. Nobody can stop the earth also from pulling things towards her, right? So these are the things that you cannot get a patent for, or relativity theory or string theory or any abstract theory. You cannot get a patent for that. Here I just wanted to give you the example that how you can get a patent also for that you think is not that great scientific discovery. On April 10, 1849, some guy named Hunt was granted a US patent. This is the patent number for inventing safety pin. So safety pin is the thing that girls will wear for pinning up dupatta or sari or like that, you do and do this. So okay, here some see some images also there here, right? You can see it. So you can understand that that is not a groundbreaking research. If you give a patent for that, everyone else will get this guy's authorization. So everyone else will pay to this guy to use that safety pin or make that safety pin. So that kind of thing will be patented. Patent applications are mostly filed from applied science departments. This is for your general knowledge. What is an invention? This is according to Indian Patent Act. Invention means a new product or a process involving an inventive step and capable of industrial application. So when somebody asks you or I ask you in the exam that what are the criteria for patentability, that is one for sure this question will come. So what is the criteria for patentability? So these are the three criteria. First of all, where is my lizard thing? Okay, first of all, it has to be novel. Secondly, it should have inventive step. Third, it should be useful basically, but in legal term it's called capable of industrial application. So these are the three things: novelty, inventive step, capable of industrial application. These are the three things that what is the criteria of patentability. Slide number 13. Please remember this question will come. By the way, sometimes this inventive step, we in India call it inventive step, but in the US they call the same thing as non-obviousness. Okay, so I have given that example also. And here I have told you the capable of industrial application means what? It should be useful or has utility. So some people call it useful. I think in the US they call it useful. The third criteria, they call it useful, and I don't remember, but some country they call it utility also. But according to Indian Patent Act, you just have to remember it has to be novel. Novel means new. Okay, it should have inventive step and it should be capable of industrial application. These are the definition. Novelty means basically new, that has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of the patent application. That is novelty. That means new product or process. Then comes inventive step. It means technical advancement as compared to existing knowledge. So somebody was asking me that if I invent some process that is useful, that is, you said something that it improves the process or something like that. So here you see inventive step, it involves technical advancement as compared to existing knowledge, or economic significance, or both, and that makes the invention not obvious to a person skilled in the art. So not obvious, non-obvious also I said. So for example, if you are making some chemical at a temperature that is 100 degrees Celsius, so for that you have to create some heater, some room, so you are there is some cost involved. But if some guy is able to make the same thing at room temperature, then that guy might get the patent. Okay, because that is economic significance. That has got economic significance. I'm just telling you in a very crude term. You have to see the patent application properly, but I'm just giving you some example that how you can get a patent also. Okay, and the last one is capable of industrial application. The invention is capable of being made or used in an industry. So that is the third point. I will share the slide. So this slide is taken from Japanese Patent Office. I will share the slide. It's very simple. You can go through it. There's nothing new to say. So there is something we call it Fosita. Fosita is a person, see the capital letter, a person having ordinary skill in the art. So how we discover, how we understand that this has got inventive step or not? If you are a Fosita and if think that that is not obvious, then that has got inventive step. So a Fosita is a hypothetical person, but it is used always in patent acts all over the world. So remember, your invention has got 3 criteria for patentability: novelty, inventive step, and industrial applicability. So if you pass all these criteria, so you might think that you are excited that you will get your patent soon, but still Indian Patent Office rejected your application. So what can be wrong? What went wrong in that case? Maybe you invented a device for theft. Maybe that was your invention. So you were sad, but that is the fact. There are something called non-patentable subject matters in India that is covered in section 3 and 4 of Indian Patents Act. Okay, so here you can see novelty, some Venn diagram, inventive step, and industrial applicability. So here is the part that has got 3 of these. But if you are in these 3, still you are not eligible for patent, because you have to see you are eligible for an invention. But for patent, you have to see whether that is coming under section 3 or not, or section 4 or not. If that is not coming under, so this part that is falling under section 3 or falling under section 4, these subject matters are not patentable. But whatever is falling here, this will be patentable. So this is just an explanation how you can understand it better. I don't think that this is some mathematical formula or like that. It's not that. Okay, where is my... Okay, I wanted... Do you guys want to take a break, or should I continue? Maybe I should continue. It's already 4:45.
You may continue.
Okay. So these are the non-patentable subject matters in India. First of all, if the subject matter is frivolous or contrary to well-established natural laws, for example, perpetual machine. So if you are not giving any input to a machine and machine is generating output, that kind of thing is not possible. So that is contrary to well-established natural law, that will not get a patent. Then if it is contrary to public order or morality, or if it is causes any harm to human, animal, plant, or health, or to environment. For example, a device to assist counterfeiting of currency notes. So that will not get a patent. Then mere discovery. As I said, that discovery, why I'm losing this every time. Okay, so discovery is not patentable. So mere discovery of a scientific principle or formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So if you go towards the beach today, you dive in the beach and you find some new species, that is not patentable. It was already existing in the nature. It is a living thing that you have discovered, but that is not an invention. Okay, so example, all basic science discovery, for example, discovery of black hole, string theory, the formula is equal to mc square, a new species, a new plant, these things are not patentable. These things are discovery. Then a mere discovery of a new form of a known substance, for example, salt, ester, ether, polymorphs, metabolite, pure form, particle size, isomer, mixture of isomer, all these things, these are not patentable. Then a substance obtained by a mere admixture. For example, if in one glass you mix water and some sugar, and so that resultant, here I have said it also, a new way of making sugar syrup, that is not patentable. Then mere arrangement or rearrangement or duplication of known devices. For example, putting a torch on top of umbrella, that might be very useful, because when you are walking on the in a dark road and you cannot see, if you have that and it's raining, so if you have that torch, maybe it's useful, but you cannot have a patent for that, because those are just, you have put two devices together. It's not that as a result it's completely different, some new result has come up. It's not like that. Then method of agriculture, horticulture, method for producing mushroom, algae cultivation, these things are not patentable. Then medical surgical process. This, please remember this thing. Medical surgical processes are not patentable in India. For example, cataract surgery. Any kind of surgery, any kind of medical process is not patentable in India. But you can get a patent for any device that will be helpful in that surgery. That you can get a patent for, but not for the process. Okay. Then plants and animal, the whole plants and whole animal you cannot patent, but this plant, only the plant if that is a new plant. So there is another kind of IP, and that can be protected under Plant Varieties and Farmers' Right Act 2001, but it's not under patent. A mathematical or business method or computer program per se or algorithm, these things are not patented. These are called copyright. Then a literary, dramatic, musical, artistic work or any other aesthetic creation, including cinematographic work, television production, all these things are under copyright. Is that a question or a noise? Assuming it to be a noise, this will be under copyright. So the next one is a mere scheme or rule or method of playing, performing mental act or method of playing game. For example, playing chess, teaching method. These things are not patentable. Then presentation of information, for example, railway timetable, not patentable. Please remember whatever I am talking about here, these things are not patentable. Then topography of integrated circuit. You have to file IC. Okay. Take. You have to file it under IC Design Act 2000, but not under patent. This is semiconductor IC, integrated circuit. Then comes traditional knowledge. Some of you were asking about this yoga thing. So this is the thing, traditional knowledge. For example, use of turmeric, neem, tulsi. These things are very well known in India. We know it since our childhood. So these things are called traditional knowledge. So I already told you that CSIR, they made it traditional knowledge digital library. This is TKDL. Till date, there are 0.29, so 0.3 million medicinal formulations are available. Ayurveda, Siddha, Unani, Yoga, these things are available there. Now, don't ask me why this patent was granted. I need to go through the application, then I will be able to understand. And this has been translated also in 5 international languages. Basically, if that is in Hindi or in Sanskrit, nobody understands what is the point of that. So they have also translated that in English, Japanese, French, German, and Spanish, and distributed and given the access to all the patent examiner, so they can understand what's there in our traditional knowledge digital library, and they don't give patent for that. So after up to this, all these things come under Section 3 of Indian Patent Act. After that, we have Section 4 also. That is just about atomic energy. Anything related to atomic energy, that they will not give you the patent. Actually, they will send it to DAE, Department of Atomic Energy. If they give the NOC, then only you can get a patent. For example, any radioactive reactant or product, these things are not patentable. Okay. So, okay. So now wake up and see. If you have not listened to last few slides, you will not be able to answer. Otherwise, you answer. So I have 8 things here. You can tell me yes or no. It is patentable or not in India.
A treatment method for diabetes is not patentable.
Okay, good. So you have been listening.
A surgical instrument is patentable.
Which one?
Surgical instrument, because the
Surgical
instrument is existing. Instrument which is not existable, just maybe invented for the new as a new product.
Yes.
Purpose.
You are right. Yeah.
Newly discovered planet. It was not a patentable.
Yeah.
Maybe
And discovered all things are not patentable.
Yeah, you guys are listening. So this is no. This is yes. This is
no.
No. This
No.
No. Now tell me about this.
New medicine is patentable.
Yes.
Okay.
New
Ma'am,
process.
second, the next
No.
one is the next new process of making a medicine. It's not patentable.
Why? Why do you think so?
Because you mentioned, no, mixing of two substances to create one.
No, no, no.
It
No,
is
no, no. It's a
patentable,
process.
ma'am.
But here the process is incorporated here. The
Yes,
process
yes.
and the product is
The whole
patentable.
process. Medicine is not like that. I mix in this yellow, in this red, and this put it like that. It becomes like some yellow and red half color, and that is medicine. It's not like that, right? So that is a whole process. That is actually patentable. Did you get my point?
Yeah.
Yes.
Okay. And then the next two.
A new algorithm is a process patentable.
Yes.
Algorithm is a copyright, ma'am.
No, ma'am.
Who are you? You are listening. What is your name?
Is it me, ma'am?
Yes, algorithm is copyright. Who said that?
Me, ma'am. Banu Prakash. Social work.
Excellent. Excellent. Yeah, he is right. You guys are not listening. He is right. Algorithm is for copyright. It's not for patent.
Yeah.
Okay. The next one, I will put one cross here. Last one.
A human-made microorganism. It's not patentable.
Not patentable.
Patentable, ma'am.
No,
Who is
not
saying
patentable.
patentable? Who is saying patentable? Okay. What's your name and what's your logic?
Madam, Pseudomonas putida is an superbug. So,
Then China should get patent
I
for
can't hear you.
coronavirus.
No, okay, that's a different thing. Okay, now we are considering on a human-made microorganism. Is it patentable or not?
No.
Ma'am, it might fall in the category of discovery.
No, you
They
tell
have
me.
evolved.
I'm asking you a question.
Yeah,
You are supposed
I'm
saying
giving
no.
you a logic. So that's why my answer is no.
madam, my answer is asking.
So I am.
It is patentable, ma'am.
I'm sorry to break your heart. It is patentable.
Yes, ma'am.
Yes, ma'am, because
Because
it is invention.
yeah, it is invention. Then say.
Yeah, it is hard work invention, right, ma'am? So any others can use it. There is no patent on that.
Yeah, you are right. But just to add in that, this is not a discovery. It was not lying down in the ocean or somewhere. You made it in
Yeah,
the
yes,
laboratory.
ma'am.
Yeah, so that is the thing.
Its own work.
This is an invention, not a discovery. Okay, you go back here where that thing was there.
Discovery means an already there exist in the world. That is we are finding. Invention is we should newly synthesize or like that, ma'am.
Tali. So discovery, see on this screen, discovery of any living thing. So microorganism is living, right? Yeah. Or if it is virus, non-living, I don't bother. So any discovery of living thing or non-living substance, that is not patentable. But when I'm saying it is human made, that means you made it.
Yes.
You made some. You took out some of the genetic parts. You cloned it. You put some different genes there. Did I don't know what you did, but you made it on your own. So that is patentable. Who understood and who didn't understand?
Understood.
Understood? Okay.
Understood, ma'am.
Okay.
Understood.
So see, I want you guys are not sleeping, but some of the people are saying because I can hear only the same voices. Huh? So out of this 120 or some people, I will not be responsible if you are not able to answer all these questions. I'm describing and explaining all these things. So these also will come in your exam. I'm not saying just these things will come, but related to these things will come. And I'm telling you all these things that will come in the exam. So if you are listening to this class, you will definitely get all the questions answered, right? The question that will come from my slides. Okay. I want everybody to get the full marks in my slides. Okay, so after all these things, your pain is still not gone. So you have to be careful about your application, your patent application having novelty, then inventive state, then industrial applicability. Okay, done. Then you see whether it is falling under subject matter section 3 or section 4. So you have checked that also.
still you have to bear some pain because the patent office will look for enablement and base mode. So what is enablement? Is that the enablement is that a patent application must also meet the enablement requirement in order to get the grant. A patent application is said to be enabled if it provides sufficient details. For example, you are thinking, if I file the patent application and if I describe all these things, then all my friends or I don't know, enemies, they will copy everything. And what is the point? I will not be able to do anything. So better hide everything. So I just write, maybe I invented, what can I invent? Maybe I invented some drug. Okay. Some of you were interested in drugs. I invented some drug. I just wrote, I mixed some chemical compound A and B and C and I got the drug. I don't mention anything else. So your application is not enabled. You have to mention under which temperature you did, which pH you did, whatever related to the chemical reaction. You have to mention all these things. Then only your patent application is enabled. So if you just write a story in 2 or 3 lines and if you send it to patent office, they will raise the objection, and while examining examining your application, they will send you back that where are the details. So your application is not enabled. So you cannot have a patent grant where you didn't at all disclose anything. So when you disclose, then only disclose properly, then only the application is called enabled, and that criteria is called enablement criteria. Then a patent application must also disclose the best mode of carrying out the invention known to the inventors. For example, if the inventors know that optimum pH condition for that experiment, they must disclose it in the application. For example, if I am saying I made that drug, the same example, I made that drug in an environment with pH ranging from 2 to 10. What does that mean? 2 is highly acidic, and then you cross the neutral part also, and then you went to basic. How the hell I would know at what pH we did it? So you are not required to give the detail like you did it exactly at 8.1, 2, 3, 4, 5, 6. You don't have to say like that. You can also say from 7 to 8 or 8 to 10. You can also say like that. You are not supposed to give 2 to 10. So that's why we say best mode. The best way to do the thing, best way to carry out the invention is called best mode. So after satisfying all these criteria, also enablement and best mode is also very important for the patent office. So this is about when you draft the application. So better you give your application to some patent attorney who will know how to do it, and you get rid of all this tension. They will take care of all these things. But this is for your information. So that's all from my part. Any question? What happened? Am I not audible?
You're audible, ma'am.
Ma'am, this patent and the copyright will be treated in the different sessions. So we clubbed the copyright along with this patent.
No. This our session is only for patenting. The understanding patenting in India, right? That is the, what is the course name? Understanding patenting in India, right?
Yeah.
Yeah, we are not covering copyright. Maybe if you guys are interested, we will take another certificate course where we will cover all the IPs. But this is focused on patent, only on patent. And patenting is most relevant and important for all the people in academia. That's why we have designed this course based on patent only.
So the writing of a new algorithm, so will comes under the discovery or the development of existing things? Why it comes under?
No, it comes under copyright. See, I told you some other things also. For example, integrated circuit layout, you cannot go for patent. We have a separate act for that. Go through that act. Okay. If you think about in some other way, I can tell you, in order to get a patent, what you have to do, you have to satisfy 3 criteria. Novelty means basically new. New, so everything will be new. Whatever you are doing, if it is not new, what is the point you are spending your time on that? So it is new. Secondly, it is inventive. Inventive means economic significance or technical advancement. Do you understand? For
Yes.
any of these things, for integrated circuit layout, for plan variety, or for algorithm, it's very difficult. You cannot satisfy the inventive step criteria. But that is a different thing. So you can go for copyright for that. Somebody was asking in the last session, software is patentable or not. Software is not patentable. Software, basic parts, say just the software, there's the coding is not patentable, that will come under copyright. But if software has got something that is giving some technical result, the whole thing you can get a patent. These are some advanced things in patenting. But only the algorithm where you have written, yes, do this, no, do that, those things are not patentable.
Ma'am, is copyright same territorial as patentability? Like, is it reasonable?
All IP rights are regional.
Okay, ma'am.
So, oh, I'm so sorry. Somebody is saying it's hard to remember all this. I will share the slide. Oh, some of you were writing here. I'm sorry, I didn't get it. From where the question started? Okay, I'm confused. Okay, I'll start from the last. Okay, can the decision to grant a patent be challenged? Yes, it can be. I think we have session also on opposition and revocation. In that you can understand it better. So it's about Kara Pavan Kumar. Yes, if a patent is granted, still it can be challenged. So we have session on that. You can clearly understand it from there. Yeah, pre and post grant opposition and revocation also. So you can challenge that also. And Ram Nishant, I will share the slide. So you see that I have told you. Then human made acrosm. Okay. Which question I'm supposed to answer, I'm not able to understand, because some of the things I can see that my colleagues, some of the things they have answered it. 2040. Oh, okay, the answer you are typing here. Okay, somebody was asking about WIPO, that also has been mentioned. Should an inventor file for patent right in each country? Yeah, that's what I said. But you have to see, you don't have to unnecessarily pay all the fees. Na? In whichever country your invention is useful, that country only you file the patent. You don't go to all, every other country that you don't think your invention is useful. You can have a market in that country. You don't go to that country, right? Okay, I think those are all the questions. Or did I miss any other question? Then please tell me. Okay, Pavan Kumar, it's possible in the US, but not in India. We cannot extend the patent term. That will be 20 years and done and dusted. In India, we do not get the extension. You have mentioned Yuva Kishore. Can I trademark the name of my business? Yes, you can. For example, all these things. So this is not a session on trademark. Still, I am saying these things, this name, whatever this name is, these names, these are all trademarks. The name, IBM, the logo, anything you see, all these names are trademarks. So yeah, you can trademark your name of your business if that is not already in use. And then Sai Kirti Lokpinti, ma'am, you have mentioned that patents are not global. Yeah. I have read somewhere that India has patented the production of basmati rice. So can any other country not produce water? That's a debatable thing. Pakistan has also got this. That is whatever I told you. That is the regular thing. But basmati is also produced in Pakistan, so they also have got IP on that. So this is, there will be something because we divided the country in between, but the same kind of land, soil, or moisture content in the soil, those things are similar here in India and in Pakistan. So they are also able to grow basmati, we are also able to grow basmati. That's one kind of IP, but that's a debatable thing. Both of the countries, they have got it, and that is not patent. That's one kind of IP. We call it geographical indication. Okay, my colleague is writing. It's not relevant to patent. GI, geographical indication. So I think you have got a lot of questions on different types of IPs, but our will be happy to answer you. But our session, the certificate course, is basically for patenting in India. Okay, so all patent related thing, it will be, yeah, please ask.
Ma'am, this is in regards with addition to patents. Any improvement made to our products?
Yes,
My
that is called
invention.
patent. Yeah, that is called
Yeah,
patent of addition.
yes, ma'am. 1999 law. Uh, again, we have to take a new patent right for that
Yes.
in toto.
Yes. So that will be a separate application. There is a lot of sound coming. Oh, thank you. So that will be a new patent application. So, but there you have to mention the main patent application number. So that will be patent of addition. Any improvement or modification of the main application, main invention, that you can get a patent of addition. But the term of the patent of addition will be same as the main patent. So if you have one patent, if you filed one patent 4 years ago, now you have improved it. So for that patent, you have 16 years left. For this patent of addition also, you have only 16 years left. So that we call it patent of addition.
Thanks a lot, ma'am. Really kind of you.
If the person varies from the original patent, suppose you, person A, had invented and got a patent on X, and the new improvement is made by another person, will get a separate patent on that?
Okay. So better you go and talk to the first guy. And
Yeah,
so
negotiation again.
this is yeah. No, this is another session, but this is a good question, very good question. So actually, it should be from the same owner. Okay. Otherwise, you go and talk to that guy and get the same, because in that application, it was not your patent, right? You were not related to that patent. So better you go and talk to that guy, negotiate among you two who will file the patent. Maybe that guy will buy your thing and will file a patent application. So that is, the thing, the arrangement you have to do among these two.
Okay.
But that is a very good question.
Got it.
How can I protect my IPR right? Why? You just file it. Simple. You have these many IPR. You have a patent, go for patent application. You have a trademark, go for trademark application. Kerala, Yuva Kishore. Yeah, you have to file it. Any other question? Somebody is asking, is there any attendance procedure? So that will be done automatically. Somebody is asking in the WhatsApp group. And I have another request for you guys, that the WhatsApp group that we have created, that is for all the useful information. Okay. If everybody is writing hi and hello, then even for me only, I have to search where is the useful information. So That's why I requested everybody to post only useful information. Shrutika Bhatia, I think you have shared one number that is +370, and with that number, yeah, you can please type your number here. I think that number doesn't have WhatsApp. That's what my students told. So you can please give your number here. What is that? Yuva Kishore, if you have got that patent, you will get higher price. So file a patent application so you can negotiate with the company also. You can get higher price because you will tell the company that today or tomorrow my patent will be granted, then I will get higher price. So before getting like, it's a good idea to. Shrutika, that is the number you already gave, but that doesn't have WhatsApp.
I'm using this number for my WhatsApp.
Okay, this number has got WhatsApp. Okay, my students, they will do it.
Thank you. And one more thing, are you guys going to provide us with a new link for tomorrow's session? Or
No. The same
link
for everybody and every day. You're welcome. And the product is already Yes, I didn't understand. If I had a patent right, a product, if I had a patent for a product, and the product had already had a patent, who will get the patent right? Okay, I didn't understand the question, Pawan. If I had a patent right, a product, and the product had already had a patent. The question is not clear to me, Pawan Kumar. Can you please rephrase it? How can I get a patent right when it already had patent? That means your invention is not.
So you mean to say that the same patent rights for having the two persons have the same patent right?
Okay, that will not happen. And Pawan Kumar, I think somebody in the chat, she has written that a patent, if it has already got the patent, the product, if you mean to say you are trying to patent it again, that is not new.
Ma'am, if you want to patent it again, either it should be a new process in that product or some new novelty research work we should be done. Then only we can get patent on that product, right?
Yeah.
If it already had.
Yes, you are right.
Otherwise, they won't give because it is not new. It is already existed.
Yeah. So for Pawan Kumar, yeah, you are right. Kirtana, you are right. But for Pawan Kumar, I can say one thing that's why it's very important to go through the patent databases. So I'm not sure what you tried to say, but maybe you are trying to say that you are trying to patent something and already somebody had got the patent. So if you are going through the patent databases, you will understand what are the patents in the world, what are the patents at least in force in India. So you will understand all these things. What are the patents that have been filed in India? You will understand. So you will not do the same thing again, reinventing the wheel, we say. So you will not do that, right?
How much it costs for getting a patent?
For filing, at first it will be 1600. Then you have to apply for examination. That is 4000. So total 5600. If you get the grant, you have to pay the renewal fee also. First few months 800, like that. Okay.
Thank you.
Okay, any other question, or we can close the session?
Yeah, ma'am, I'm done from my studies. So may I leave now?
Yeah, sure.
Yeah. Thanks for all your effort and thanks by the this time. I will be joining tomorrow.
Yeah, sure. Thank you.
Bye, guys. Bye.
So, if anyone has any question,
Yeah, dear students, I think you had a very good questions. I was hearing some of the questions raised by all of you. The questions are very, very interesting and very high level understanding is required. Somebody asked, suppose I have already, someone has got patent granted, and if you want to file a patent, is it possible? This is very basic and understanding is required. Patent is given for a new one, novel one, novel inventive step and industrial use. So always, if your patent, the technology may be same, or the process may be same, or the product may be same, but if there is an improvement over the existing patented technology, you will get a patent. You can always apply. So that is how you will prove that your product or your process is better than the existing process for which you are seeking patent protection. So always there should be an improvement over the existing product, existing process, then you can apply for the patent. That is very, very interesting question someone has asked. Second point I would like to clarify, someone has also asked the difference between discovery and invention. Discoveries, as per the Patent Act, they cannot be patented. What are patentable? Using the discovery, if you develop a technology, they are patentable. No, this in many competitive examinations, this question is a standard question, whether discoveries are patentable or not. But all of you should know discoveries cannot be patented. Like discoveries means the theories or like what Dr. Ananya has mentioned, E is equal to mc square or F is equal to ma or the Newton's laws, all these things are called discoveries. Using those discoveries, if you are able to develop a technology or a product, that is patentable. That is called invention. So, for example, Newton's third law. What is Newton's third law? Most of you may be knowing, all the science students. Every action has got equal and opposite reaction. No? Every reaction has got equal and opposite reaction. That is Newton's third law. But Newton's third law per se cannot be patented. It is existing already in the nature that Newton has discovered that. No? That is why it is called a discovery. But the application of the discovery, where it has happened, all the rockets, aeroplanes, which were product of this discovery. Using this discovery, they have developed those technologies. So they are all patentable. The discoveries per se are not patentable, but whereas inventions or innovations which comes out of the discoveries, which use the discovery, for example, Raman effect, which is a very well-known effect in the physics. Using that effect, people made products. What is called Raman spectrophotometer. It works based on the discovery of Sir C.V. Raman, who discovered the Raman effect. So like this, there is always a difference between discovery and invention or innovation. So this is a very, very important question somebody has raised. I'm very happy to I'm happy to note that all of you have got some prior knowledge, on intellectual property rights. It's very, very useful. I'm sure at the end of the certificate course, all of you will be enriched with more knowledge than what we are currently having. That much we can ensure all of you, provided if you raise good questions for each resource person. See, the faculty member just tries to give you an overview of that topic, but more questions can be answered, more doubts can be clarified only if you ask questions in the particular domain. It is not possible for the resource person to cover the entire area. We can give you the flavor, we can give you the basic concepts, but you need to come out with more doubts and more questions so that all of you will get benefit out of this special class or special certificate program which we have planned for all of you. Thank you very much, and see you tomorrow again at 2:30. All of you, please join. We have received money from 208 participants, but whereas I'm surprised to see hardly only around 68 people are still online. This is not good sign. Tell all your friends who have paid money through their nose. 1,000 rupees is not a small amount. No, but you should attend all the classes. Even if you pay 1 lakh rupee, you will not get this kind of experts to talk to you about intellectual property rights. So please make use of this opportunity and interact with our